morning, Judge Sue Offer, Leslie Basie, and Zach Woodchow appear on behalf of the state of Wisconsin.
Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charges instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to being called that name.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is in street clothes, wearing a suit and tie and a mask.
I don't consent to being called that name, Your Honor.
I understand,
For the record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case. And other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that, I don't agree to that, Your Honor, or consent to that. Your lack of consent is noted. As I told the parties on Monday, I had excused one of the jurors for a health reason, and it has come to my attention that I now have a second juror with the same health concern. Out of an abundance of caution, I am going to bring the jurors out to question them about their, whether any of them have any concern about continuing to serve on this jury, given the health concern. I am referring to a COVID concern.
Your Honor, will we be addressing subject matter jurisdiction?
No, not at this time.
Still has yet to be proven for the record. I don't know if the audio is on, but
I wanted to make a record in open court and to ask each one of you if any of you have any concerns about continuing your service in this case due to exposure to COVID. And so I'm just going to go through, first of all, juror number 11. Do you have any concerns about continuing your service in this case, specifically related to COVID?
No concerns.
All right, thank you. Let me actually go back. Would the fact that you may have been exposed in any way interfere with your ability to pay attention and ultimately render a verdict in this case?
No.
All right, juror number 48, if you could also answer those two questions.
No concerns, both ways.
All right, and thank you. Juror number 46.
No concerns.
Thank you. Juror number 34.
No to both.
Thank you. Juror number 27.
No, also to both.
Juror number 30.
No concerns to both.
Thank you. Juror number 1.
No concerns to both.
Thank you. And what's your number? 6. Juror number 6.
No concerns to both.
Thank you. And juror number 14. I'll just start there.
No concerns to both.
Thank you. Juror number 10.
No concerns to both.
Juror number 51.
No concerns to both.
Thank you. Juror number 45.
No concerns to both.
Thank you. Juror number 19.
No concerns to both.
Thank you. Juror number 41.
No concerns to both.
Thank you. And juror number 3.
No concerns to both.
Thank you. I'm going to excuse the jurors then, and then when we're ready, we'll have you brought back out. And thank you so much. So, unless there's anything related to that, I have a couple of other issues I need to address this morning.
I got something for that.
Go ahead.
The person that's, or the two people rather, that are having the COVID concerns. I know you said you wasn't going to ask them had they test positive or the results of any testing. Do you know if there has been exposure on their end to COVID exactly, or is that just a caution thing?
My understanding is that I've had 2 jurors test positive throughout the course of this trial. And I'd make a further record that they're the only ones within 6 feet of each other. Obviously, you're not within 6 feet of any of them, but that's a good question to ask, and I'm glad you asked that, and I wanted to make a record of that as well.
Yeah, that would be my question to it. I guess in reference to me myself just having the same concern a few weeks ago. So that would be the reason why I would want to know exactly any details that could be provided.
I'm providing all the details that I will. Again, for the record, you have not been exposed, from my opinion, because of the distance that you are away from them, and my understanding based upon my review of county policy.
The entirety of the jury, though, have they been exposed in any way?
I don't know the specifics because of the 6-foot rule, and no one has asked me to investigate that further.
Wouldn't it be smart, though, to see?
I don't believe that's necessary under the circumstances.
Well, if anything, just for future reference, like, what if it plays a part later on?
Well, I'll certainly take your concerns under advisement, and if I believe any further questioning needs to be done, I'll do that. At this point, I don't believe it needs to be done, but I'll think about that, and I'll take it under advisement, and if I change my mind, I'll let you know.
Yeah, I'm just saying, because if anything, it probably would be smart for the long run to make sure no one else was compromised, considering that.
Let me make a record there. No one has indicated they are compromised. I don't think we can make assumptions about how anyone who's been exposed or tested is feeling. You can be asymptomatic and test positive. You can have mild symptoms. I trust my jurors that they would report if they're not able to sit through the proceedings.
Seemed like the circumstances were different when it was me. Just saying.
Are you making any specific requests given this information?
Well, I believe that the jury clearly all congregate together. I think it would be smart to make sure everybody is tested. I mean, that's it would be smart to do that.
I'm not going to mandate testing for the jurors. That much I can tell you. So that request is denied.
And the grounds for the denial?
I'm not going to mandate that the jurors be subjected to testing. They're the ones who indicated they are comfortable being here. They don't have concerns. And again, I would trust them to report to me if anything changes.
I'm quite sure, though, that all the jurors Monday said they didn't have any concerns as well. And then now today, someone else. Same thing being said. I just feel like it's smart for them to be tested, so it doesn't come up again in the future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go. It's just smart to, like you say, err on the side of caution.
I appreciate that. I'm going to continue. I understand what you're saying, but given the responses of the jurors today, I'm going to continue. I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that, though, Mr. Brooks, I have been thinking about your request yesterday, and I know I indicated to you that I would require you to be there. I've rethought that. I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this. I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
I was still confused about why did there even need to be a jury view. That was my whole thing. I don't see the relevancy of it. And I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that. Do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you, though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. It's The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person, I'm a human being. And no, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
If you don't, it's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
By law,
But you can forfeit your right or to
I
be
didn't-
there
I
by your
didn't-
conduct. And
I
by your
didn't-
conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've
Yeah.
had some time to think about that further, and I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
so why did I have to do that for when my
I'm not going to answer those questions because that
Well,
would be for me to give you an explanation of the law.
no?
I'm
it
just
would
going to
be-
tell you that I'm not going to require a written waiver from you in order to honor your request to not be at or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
Sir, I'm not
The
going to
way-
go through all the law that applies to that.
The way
This is
I-
my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But
No,
your lack
Your
of
Honor.
consent is not going to stop the jury view. It's
It-
going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up, on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know
Which
what
was-
I said, and
Yeah.
I'm telling you I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more, and I'm changing my mind. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your
If I'm
objection
not-
is well noted for the record. I need to keep going though on the pattern and
I'm
jury.
informed that you need to keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause, that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing. I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not
that
arguing.
We will continue on with the next
topic.
topic.
Understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties 2
May I
documents.
respectfully reject that ruling and take exception to that ruling?
Your objection is noted. I'm
For the
moving
record,
on
may
to
I
jury.
request a legal and factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments.
raising
and then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not disruptive.
And it's interrupting and it's disruptive.
It is definitely not disruptive.
Well, if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone. And once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152.
Well,
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, Mr. Brooks, please stop. You're continuing to talk over me.
Because
you're interrupting.
You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you
Okay?
didn't. I was right in the middle of
Your objection
it.
comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before we
stop.
even finished,
That's not true. Okay?
you
It's
said
not
I'm going to
true.
make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
going
the
to
time to
spend
think.
hours on end making a ruling about a jury view on something I've already decided. All right? So please, I'm asking you to stop. Stop
No,
interrupting me.
You can't,
and please
you can't
listen.
just disregard the United States Constitution, which has a
I
supremacy
absolutely am
clause.
not disregarding the
You are.
United States Constitution
You're not
or the
honoring your oath
Constitution
of
of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want
didn't
you in
cross
this
any
courtroom.
line.
But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this morning.
So again, you're holding me in contempt.
All right. Jury instruction 152. Has the state had an opportunity to review it?
Is that a judicial determination that I'm being held in contempt?
Instead of referring it as being in the Waukesha County Jail, I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Seem to being called that name. And what do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes.
I accept for value in return for value this document. Now, I'd like the record to reflect I still haven't received my original copies of my filings here this morning.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value document.
Do you have any position on the state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully,
sorry?
for the record, may I do that? It seemed like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That was
Reference to
accepted for value
the-
and returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
Let me know when you're finished reviewing it, and
I don't have to review the same document that was reviewed yesterday, accepted for value and returned for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself.
With that, sir, do you have any?
I don't
Position.
fundamentally understand that. I think everyone's well aware that I'm in custody. So how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody. How does changing the wording change what's already known?
Thank you. This instruction will be read while we are still in the courtroom prior to the parties in the court going to the Sallyport for that viewing, and I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding is we'll have sort of assigned places, and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we have
So
preliminary.
I don't understand it.
We had preliminary discussions at the time of the request back in August when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail, to talk about it and the logistics of it. And then, of course, we're having the discussion now. I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it. Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file, and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same
So-
details that's being discussed right now at this moment?
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely with bailiffs. I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly,
And-
Your Honor?
So, obviously when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are
The security has to be left at the discretion of the sheriff's department.
Actually, these are leg shock devices, not shackles.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see
That is to your benefit.
shock?
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that
Yeah.
you're making about your lack of understanding, I need to move on with the other topics
There is
I
a
need to
specific
cover.
request. Why do I have to have ankle shocks on my ankles to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're a shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention. But we are going to move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No,
I'm
it's
not
one
going
document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, again, I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every filing that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this.
Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
All right, I'm going to move on.
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to something?
I don't believe there's any other preliminary issues we need to address.
I'm still wondering when I will get the copies back for the ICFs that I filed.
I can't answer that. I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her by an inmate communication form and ask her for those. But I'm not going to address that any further on the record. All right, let's
should
bring the
be.
jury up.
It's kind of funny that they disappeared. No,
That
ICF
assumes
disappeared
a fact,
before.
Not an evidence, sir. So
They haven't disappeared before. I've always got copies. What's the difference now? So I have to readdress her the same thing in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but
So what happened to this one being forwarded to you?
Sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying to
in. We're
avoid
going to
it. That's
we're
what
going
it
to
seems
continue
like.
with the trial. So thank
Just like
you.
you've avoided subject matter jurisdiction. You haven't proven that on the record.
Are you aware as to whether or not the school district maintains security cameras at the buildings on the school district property?
Yes, we do.
Overruled. It's foundational. The witness may answer.
I'm sorry.
Yes, we do.
Okay. And specifically, is there school district property located at the address of 222 Maple Street or Avenue in the city of Waukesha?
Yes.
Overruled. It's foundational.
Is there more than one security camera on that building?
Overruled. The witness may answer.
Yes.
How many are there, sir?
Overruled.
When the police came to you in the days following November 21 of 21, did they ask you to check a certain day and time on the video recording for the building at 222 Maple?
Objection.
Overruled. The witness may answer.
Had you changed or altered the content of the recording in any way?
Objection, leading.
Overruled. The witness may answer.
No, I have not.
Do you recognize what we're seeing there, sir?
Yes.
Could you please tell us what is shown on the front screen of Exhibit 157?
Objection, leading.
Overruled. The witness may answer.
This is the side of our Lindholm Administration Building at 222 Maple.
Okay. Do you believe the video contained in Exhibit 157 will be a true and accurate depiction of the events from this location on November 21 of 21.
Objection. Speculative.
Do you want him to see the video first? Why don't you show him the video first?
Well, the video is 20 minutes long, Your Honor.
Oh, all right.
Or I'm sorry, 11 minutes long. Do you recognize what is shown in Exhibit 158?
Yes.
Please describe it.
This is,
Objection leading.
Overruled. The witness may answer.
this is our rear parking lot at the Lindholm Administration Building.
At that same address?
222 Maple, yes, that's
Okay.
correct.
Is this a second camera?
Objection leading.
Correct.
Overruled.
Entire video is 11 minutes in duration. Based on the testimony of the witness, I do not intend to play any of it at this time, but I would move to admit 158.
Objection. It's not intended to play. What's the relevancy?
The objection is noted. It's overruled.
Do you recall when you saw those videos?
I saw those Monday morning when my detectives came and asked me to review video footage.
And do you recall the name of the detective that you reviewed the footage with?
I do not recall the name of the detective, no.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
Were you subpoenaed at any time?
Yes, I was.
And do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled. The witness may answer.
The district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustained as to the form of the question.
Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement.
Grounds.
Sustained as to the form of the question.
Do you recall having a phone conversation with the plaintiff in this?
Same
matter?
objection.
Grounds.
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I'm not sure who the plaintiff is. Can you define that for me?
The plaintiff would be who's bringing the claim.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified, this is irrelevant questioning.
We'll see what his question is first.
I asked it.
Please ask your question again so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
Do you even know if there's a plaintiff in this matter?
Objection
Grounds.
argumentative.
Sustained as to the form of the question.
Have you yourself filed any complaint in this matter?
Objection
Grounds.
irrelevant.
Overruled. The witness may answer, sorry.
I have not, no.
Do you know of anyone who filed a claim in this matter?
Objection
Grounds.
irrelevant.
Overruled. The witness may answer.
I do not.
Do you have any security cameras at your home, sir?
I do.
And do the security cameras have a way to record or save events that are captured on the camera?
They do.
Objection leading.
Overruled foundational.
To your knowledge, sir, was your security camera system operational on November 21 of 2021?
Objection
Yes.
speculative.
Overruled. The witness may answer, and he did his answer.
Was there a time where you turned over video from that security system to Waukesha Police sometime around November 21 of 2021?
Objection leading.
Overruled. The witness may answer.
Yes.
What kind of security camera do you have, sir?
Objection leading.
Overruled. He may answer, sir.
It's just a generic NVR system.
Before you turned it into the officers, did you alter the content of the video in any way, sir?
Objection
Absolutely not.
speculative.
Overruled. Please wait, sir. Overruled. The witness may answer.
Absolutely not.
I'm going to have Exhibit 155 displayed on the screen in front of you, sir. Do you believe that's a true and accurate capture of the events at your residence on November 21 of 21?
Objection speculative.
Overruled. You may answer.
It is.
I notice in the upper right-hand corner of the video there appears to be a date and time stamp. Do you see that?
Yes.
Objection relevancy. Any idea exactly what we were looking at?
Recorded footage of my backyard.
Pretty standard to any other footage from any other day?
I guess I don't understand that question.
Is it pretty much the same thing you would see any day if you viewed that footage?
It's recorded footage of my backyard.
Is it pretty much the same footage you would have saw if you viewed it every day?
Sure.
And do you recall if you were subpoenaed to testify in this matter?
Yes. Yeah, I received a letter.
Do you recall by whom?
Waukesha County was on the envelope. I don't remember the names on it.
Did you yourself at any time file a claim in this matter?
No.
Do you know of anyone who has filed a claim in this matter?
No.
Have you ever talked to the plaintiff in this matter?
Objection.
Grounds.
Sustained as to the form of the question.
Have you yourself ever reached out to the plaintiff in this matter?
Objection.
Grounds.
Sustained as to the form of the question.
Have you ever had any personal interaction with the plaintiff in this matter?
Objection.
Grounds.
Vague, argumentative, irrelevant.
Sustained.
Sustained for those reasons stated by.
Sustained as to the form of the question as well.
Are you sure if there's a plaintiff in this matter?
Objection.
Grounds.
Argumentative, irrelevant.
Sustained for those reasons.
Were you at any time informed that there's a plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Sustained.
For the reasons stated by.
Sustained.
For the reasons stated
Yes.
by the state.
Also as to the form of the question.
Have you at any time seen anywhere or read anywhere that there's a plaintiff in this matter?
Objection, Your
Grounds.
Honor. Irrelevant.
Grounds.
Sustained. Also as to the form of the question.
Sir, on November 21 of 2021, where did you live?
435 Dunbar?
Is that here in the city of Waukesha?
Yes.
And is that your home?
Yes.
Overruled is foundational.
Do you have any security cameras at your home, sir?
Yes, I do.
And did you back then in November of 21?
Objection leading.
Overruled. The witness may answer is foundational.
Yes.
To your knowledge, were they in working order on November 21 of 21?
Objection, speculation.
Overruled. The witness may answer.
Yes.
Does your security camera have recording capability?
Objection, leading.
Overruled. The witness may answer.
Yes.
Close to November 21 of 2021, maybe a day or two later, were you contacted by the Waukesha Police Department?
Objection, leading.
Overruled.
I was contacted on Monday and on Wednesday.
Did they specifically obtain recordings related to the date of November 21 of 21?
Objection, leading.
Overruled. The witness may answer. It's foundational.
Yes.
Did you change the content of the recording in any way?
Objection,
No.
leading.
Sorry.
And speculative.
Overruled. As to both objections, the witness may answer.
Nothing was changed.
This is a 9-second clip. Can you see that, sir?
I can.
And if you look on the screen, sir, do you see a date and time stamp for the video?
Yes.
Objection, leading.
Overruled. The witness may answer.
What was the date and time stamp that the video was recorded, please?
November 21, 2021 at 4:46:41 p.m.
Would you say it's fair to say that from the video, this is a pretty good distance from where your camera was positioned?
That video image is a good distance. It's about 50 yards.
And you can tell from the video that you just watched today, you can tell the gender of the individual that you saw crossing the street, as you say?
Well, when I saw it originally, I had zoom. Okay, the feature of the camera zooms, so your image was real clear.
So the image was real clear when you had zoom. Any reason why this particular image doesn't have that feature?
They can do whatever they want.
Grounds.
Objection.
Hold on. There's an objection.
Sorry.
Let me rule on it.
Beyond the scope of the witness's knowledge, Your Honor.
I'll overrule if you know the answer.
I don't know what decisions they made in choosing the display.
And do you recall when you were subpoenaed to testify in this matter?
Late July, early August.
Do you recall by whom?
Waukesha County District Attorney's Office.
Do you recall whose name was on that subpoena?
I would have to take a look at it to recall it.
Did you yourself at any time file any claims in relation to this matter?
No.
Do you know of anyone who filed any claims in relation to this matter?
That's a privacy issue.
You may answer the question.
I know that my grandchildren received counseling, and I think that a Waukesha Community Fund might have helped cover some of that.
Do you recall the name of the fund?
No.
And to your knowledge, the fund that you speak of was strictly geared towards counseling?
I'm not privy to what it was geared toward.
So would it be fair to say that there was a financial interest attached to this incident?
Absolutely not.
And
There's a
did you
mental
come-
health interest.
And how's everybody doing now? Are they okay?
Objection irrelevant.
Grounds
Sustained.
for relevance?
Yes.
Have at any time you yourself had any personal interactions with the plaintiff in this matter?
Objection.
Grounds.
Sustained as to the form of the question.
Do you know if there is a plaintiff in this matter?
Objection.
Grounds.
Relevant.
Sustained.
Grounds for the sustain, Your Honor.
Not relevant.
Do you recall if the plaintiff in this matter reached out to you in any way?
Objection.
Grounds.
Irrelevant. Asked and answered.
Grounds.
Sustained for those reasons. Also as to the form of the question.
Just for the record, it wasn't asked and answered. Just for the record.
Next question, please.
Do you yourself know if there even is a plaintiff in this matter?
Objection. Argumentative.
Sustained as to the form of the question.
Mr. Miller, on November 21 of 2021, where did you reside?
Overruled, the witness may answer.
126 Central Avenue,
That's here in the city of Waukesha?
Waukesha, yes.
Okay. Do you have any home security systems in place at your residence, sir?
Objection speculative.
Overruled, the witness may answer.
Yes, I have 2 doorbell cameras. I noticed somebody running up my driveway on the one camera.
Did you
So
recognize the person?
I did not.
Okay.
Sorry.
Hold on, there's been an objection. It's overruled. His answer may stand.
So you saw somebody on the recording that you did not recognize.
Correct.
Objection leading.
What?
Hold on. Overruled.
Asked and answered.
It's foundational. I'll allow it, but please move on.
It's asked and answered already.
What did
Go
you?
ahead.
I believe it was a detective called me and asked if I could send them the copy of the video.
Did you do that?
I did.
Prior to doing that, did you alter the content of the video in any fashion, sir?
No,
Speculative.
Overruled.
Mr. Miller, is that the recording you provided to the Waukesha Police Department?
yes,
Do you believe this is a true and accurate depiction of the events at your home on November 21 of 2021?
Objection relevancy.
Overruled. You may answer.
yes,
In the upper right-hand corner of the recording, I noticed there's a date and time stamp. Do you see that?
yes.
Objection leading.
Do you believe that was
on.
accurate?
Overruled.
I'm sorry.
There's the witness's answer may stand.
When you received the subpoena, did you follow up with the district attorney's office? I'm assuming that that's who served the subpoena.
I did.
Do you recall whom you spoke with?
I do not recall the name. Sorry.
Did you yourself file any claims in relation to this matter?
I have not.
Do you know of anyone who filed a claim in relation to this matter?
Personally, no.
To the best of your recollection, do you recall being contacted by the plaintiff in this matter?
Other than regards to the summons, no.
And you made reference to the summons.
Or subpoena, rather.
What was the plaintiff's name on the subpoena?
I believe so.
Do you recall what that name was?
State of Wisconsin.
Have you ever had any interactions with the state of Wisconsin?
Objection.
Grounds.
Irrelevant, vague, argumentative.
Grounds.
Sustained.
For those reasons, Your Honor, or
Sustained. Yes.
being that you identified the state of Wisconsin as the plaintiff, have they ever reached out to you in any way?
Objection.
Grounds.
Sustained as to the form of the question.
Have you ever had any personal interaction with the state of Wisconsin?
Objection. Vague,
Grounds.
irrelevant, argumentative.
Grounds.
Sustained.
For those reasons stated by.
Yes.
Would you yourself classify the plaintiff that you identified, state of Wisconsin? Would you classify them as a living human being?
Objection.
Grounds.
Vague, irrelevant, argumentative.
Sustained for those reasons.
Would it be fair to say that a state cannot be a human being?
It could be argued philosophically, I guess, yes.
And
But I don't know. No.
no?
Personally, no. But philosophically, I suppose you could argue that the state is a person.
The state, one state?
I suppose it could be argued.
And with determination, how did you come to that determination?
Objection. He said he did. Your Honor, that's a misstatement of his testimony.
Sustained is to the form of the question. It's also not relevant.
Do you see the state of Wisconsin present in the courtroom today?
Objection. Irrelevant.
Grounds.
Sustained. Not relevant.
What was the last part, Your Honor?
Not relevant.
Have you ever seen the state of Wisconsin at any time?
Objection.
Grounds.
Argumentative.
Grounds.
Irrelevant.
Sustained for those reasons.
What reasons? I didn't hear.
For those reasons, it was also asked previously, and I sustained the objection.
That question wasn't asked previously, for the record. So to the best of your knowledge, is the state of Wisconsin an injured party in this matter?
Your Honor, I object. And
Grounds.
ask you to direct the defendant to move on.
Grounds.
The objection
I
is
think the judge
sustained.
has to do that, not
Pursuant.
the VA.
The objection is sustained. Next question, please.
I'm sorry, I didn't hear the reason for the sustain.
It's not relevant.
Your Honor, I object to it not being relevant. He clearly stated
Mr.
the
Brooks,
plaintiff.
please move on. I've made my ruling. Thank you.
I don't know how that's not relevant. Seems to me that there's no plaintiff.
I remind the jury to disregard comments made by the parties. They are not evidence.
There's no plaintiff.
Your Honor, for the record, subject matter jurisdiction, as yet to be proven for the record.
Your objection to that is noted. I'm declining to revisit that issue, sir.
Is that a judicial determination?
It is.
Directing your attention to the date of November 23, 2021. Were you on duty that day?
Yes, I was.
What duties were you tasked with on that day?
Me and several other officers, detectives were tasked with being part of the search team canvassing the area for items.
Okay, and this was related to the investigation into the Christmas parade?
Objection, leading.
Yes.
Okay.
The objection's noted. It's overruled.
So you said the purpose of the team was to look for items, did you say?
Objection, leading.
Overruled.
Yes, items that we believe Mr. Brooks, Darrell Brooks, was wearing the night of the incident.
What day was this that you set out to do this?
November
Objection,
23rd,
leading.
2021.
Was there an objection or not?
Yes.
Overruled. The witness may answer.
It was November 23rd, 2021.
Did you personally recover any items of interest in this case, sir?
Yes, I did.
Can you tell us about that?
Yeah, the first item that we located was a blue sandal, or they also call it a slide, that was located at 322 Maple Avenue in the backyard.
Is that on your screen, sir?
Yes, it is.
Do you do you recognize what is depicted in Exhibit 94?
Objection, leading.
Overruled. You may answer.
Yes, I do.
Tell the jury what you see in 94.
It is the blue sandal that was outside the chain link fence area like I described. It is a navy blue in color, and it also had a Milwaukee Brewers logo album on the front of the sandal, which appeared to be like torn or worn.
Do you believe Exhibit 94 is a true and accurate depiction of the area where the sandal was found?
Yes, I do.
And the exact location where the sandal was found?
Objection, leading.
What is shown in 95?
The navy blue sandal that I just described.
Similar, or how is 95 different from 94?
Objection leading.
Overruled, you may answer.
They were the same exact sandal, just different pictures.
That's what I mean. What's the difference between the photographs?
Objection leading.
Overruled, the witness may answer.
Just the angle of where the picture was taken.
You had described in your testimony a chain link fence, correct?
Correct.
Does that separate two properties?
Objection leading.
Overruled, the witness may answer.
Yes, it does separate two properties.
And what are those properties, please?
Objection relevancy.
Overruled.
You set out to search the area around 338 Maple, correct?
Yes, that is correct.
And what was the significance of that address, please?
That was where the vehicle was located that Darrell Brooks was driving the night of their Christmas parade.
Okay. And could you please approximate for us the distance between the residence where the vehicle was found and the residence where this sandal was found?
Objection relevancy.
Overruled, the witness may answer.
This is an approximate guess. I guess around 200 yards.
Can you please circle the sandal in the photograph? All right, thank you. All right, now 95 is up, sir.
Same thing? Circle?
Sure.
Objection leading.
Yes, please circle.
Overruled, the witness may answer by circling.
All right. I'd like to show you a piece of physical evidence that's been marked as State's Exhibit 86. If I could get the assistance of the deputy, please. Could you please present that to the witness for me?
Was that, you said 86?
I was going to ask the same thing because I missed that too. Can I have the number again?
Yes, 86, Your Honor.
All right, thank you. Exhibit 86. Not yet.
Sir, have you seen Exhibit 86 before?
Yes.
What is 86?
86 is the sandal that I located outside of 322 Maple Avenue.
One we were just seeing in the photographs 94 and 95?
Yes.
Okay. Move to admit 86, Your Honor.
Objection relevancy.
Overruled, Exhibit 86 is received.
Officer Becker, did you find any other items of significance to this investigation?
Objection leading.
Overruled, the witness may answer.
Yes, I did.
Where did you find these items?
I located a children's playhouse. This children's playhouse was made of wood, and it had about 4 or 5 steps up till we got to the platform of the children's playhouse. There also was a slide connected to it that would lead down to the grass. I located in that platform area, I located the gray hooded sweatshirt that had a multicolored design. It's the same sweatshirt that we believe Mr. Brooks was wearing during that parade.
All right, Officer Becker, could you please circle for the jury the children's playhouse that you've been describing for us? And where's the, this is a close-up of that same playhouse?
Yes.
Do you see the sweatshirt in this image, sir?
Objection leading.
Overruled, you may answer.
Yes, I do.
Please circle it. And those are the 2 items together in the top portion of the playhouse, is that right?
Yes, that is.
All right. Number 84. Do you recognize item number 84, sir?
Yes.
What is that?
Objection leading.
Overruled, I'm sorry, what was the number again?
84.
All right. Go ahead, you may answer, sir.
Yes, this was the gray hooded sweatshirt that I located in the children's playhouse.
All right. And 85. Thank you. Please identify.
This is the other sandal, which was a left-footed blue sandal slide. with the Milwaukee Brewer logo that was also located in the children's playhouse.
Objection, relevancy.
Overruled. Exhibits 84 and 85 are both received.
And I'd like to ask, with the court's permission, if 84 can be published by the officer standing up and holding up 84 for the jury to view.
Objection, relevancy.
Permission granted.
So please hold up the sweatshirt, sir.
Objection noted.
Yes. The record to reflect the officer stood up in the jury box. He is holding the exhibit between his waist and forehead. That's the full length of a sweatshirt, and he has passed it from right to left of his body in front of the jury.
Thank you. And then if you would do the same thing, please, sir, you could set that one down, and if you could hold up 84 and 85, one in each hand, and display those for the jury, if that's okay, Your Honor?
Go ahead.
I'm sorry, 85 and 86.
Objection.
Your objection's noted. Go ahead. The witness is standing up still in the witness box. He is holding each one of those exhibits, which I believe is 85 and 86, one in each hand at shoulder height, and he turned a bit from right to left in front of the jury.
You testified earlier in questioning, well, rather, let me back up. You said the name of the alleged suspect when questioned about the alleged suspect fleeing from the vehicle. At that time, did you know the name of the alleged suspect?
Yes, we did.
And how did you obtain that information?
From detectives working the case.
So you yourself didn't know until you were told. Would that be fair to say?
I was part of the brief, so I knew too.
So you knew before you were briefed?
Yes.
So you knew before you were briefed, then why did you have to be briefed about that information?
Just the gatherings, we briefed every morning, and the gatherings from the day before, what we were all going to do.
And in reference to the sweatshirt that you observed in the children's playpen, do you have any information on how that got there?
Not exactly, no, because I didn't follow the footsteps of Darrell Brooks that night.
You testified earlier, and I don't want to misquote you. I think it was some question of determining the distance. I don't know if that was in reference to where the vehicle was found and where the items that you found were located. Was that the distance that was being referred to?
Yes, I believe so.
Thanks for that clarification. I didn't want to misquote you. How were you exactly able to determine the exact distance of that?
I wasn't able to. I think I may have stated it's a rough estimate or approximate.
So it'd be fair to say you don't know for sure the distance?
No, I do not know for sure the exact distance.
Would it be fair to say that these items have been kept for quite a while now? Would that be fair to say?
Yes.
Are items usually kept for this length of time in the investigation?
Yes, typically yes, till the case is over.
So it isn't unusual in any way to see items kept roughly a year or so?
No, that's not unusual, especially if it's evidence to a crime.
To the best of your knowledge, did you yourself file any claims in this matter?
No, I did not.
You know of anyone who filed any claims in this matter?
No.
Have you at any time saw or read a complaint in this matter?
No.
And do you recall who you were subpoenaed by to testify in this matter?
Yeah, state of Wisconsin.
And who do you refer to when you say state of Wisconsin?
District Attorney's Office, Waukesha County District Attorney's Office.
Do you recall whose name was on the subpoena?
I do not recall. I'd have to look at the paperwork.
So to the best of your knowledge, would the state of Wisconsin be the plaintiff in this matter?
Yes.
And do you see the state of Wisconsin plaintiff in court today?
Objection.
Grounds.
Proper vague question.
Sustained as to the form of the question.
Is the plaintiff present in court today, to your knowledge?
Objection.
Grounds.
Irrelevant, legally inaccurate statement, Your Honor.
Sustained.
Do you recall having any personal interactions with the plaintiff in this matter?
Objection vague.
Grounds.
Sustained as to the form of the question.
Have you ever been contacted by the plaintiff in this matter?
Same objection.
Grounds.
Sustained as to the form of the question.
If you were to see the plaintiff, state of Wisconsin, will you be able to identify him?
Objection argumentative.
Sustained as to the form of the question.
Would you classify the plaintiff, state of Wisconsin, as a human being or an entity?
Objection irrelevant.
Sustained.
Would it be fair to say this isn't your first time during your career testifying in any type of criminal matter?
Yes.
Yes, as in?
I have testified before.
So it would be fair to assume that you understand plaintiffs and defendants, correct?
Objection
Grounds.
irrelevant.
Sustained, not relevant.
Are you aware that only a living human being can bring a claim against a defendant?
Objection irrelevant. Argumentative.
Grounds.
Sustained for those reasons. And as to the form of the question.
To the best of your knowledge, who can bring a claim against an alleged defendant?
Objection irrelevant.
Sustained, not relevant. Ladies and gentlemen of the jury, you will now be taken to a garage attached to the Waukesha County Courthouse to view the vehicle recovered by the Waukesha Police Department. You will be taken to the garage by the jury bailiffs. During your trip to and from the garage, you are not to discuss this case with anyone. While at the garage, you are not and no one is to talk to you about the case except the judge. You are to remain with the other jurors. You are not to conduct an independent investigation now or at any time during the trial. The court is taking the jury to the garage to provide the jury with an opportunity to view the vehicle, as it is not possible to bring the vehicle into the courtroom. Other than the vehicle, anything you see there is not evidence in the case and should not be considered as evidence.